Hello, I'm Ben Stepney. I'm a partner in the employment team at Thomson Tanner Passmore, and today I'm joined by Ashley Matthews, who's an associate in the employment team. Today we're going to talk about alternative dispute resolution in the employment tribunal, and particularly picking up on the recent presidential guidance that's been issued regarding alternative dispute resolution. So Ashley, to start us off then, what is alternative dispute resolution?
So alternative dispute resolution is just a term that's described to the methods to resolve disputes outside of a court setting. In the employment tribunal, there are four key ADR methods. So you've got ACAS, which is conciliation services that will be available throughout the lifespan of the claim. You've got judicial mediation, which is facilitative rather than evaluative. So you'll have a judge going between the parties, carrying offers and reasoning, and trying to manage expectations, but without giving kind of a view on prospects. You then have judicial assessment, which involves the judge making a practical assessment, so they can give a view on prospects of success with a view to trying to reach an agreement. You then have dispute resolution appointment. So that's quite similar in the sense that a judge will endeavour to provide a view as to whether either party is being unrealistic in terms of any of the issues or potential remedy. So the first three, most people will be quite familiar with if they've had any sort of participation in tribunal proceedings previously. The fourth one, which is the dispute resolution appointment, that's a relatively new method. So that was only piloted in 2020 in, I think it's Midlands West Employment Tribunal, but they're now rolling that out nationally. The standout point about that is it's the only one which is actually doesn't require the consent of both parties. So essentially a judge can just say, just make an order that parties have to participate. But just like judicial assessment, they're not bound by the outcome of that assessment. So the presidential guidance provides detailed guidance on all the different types of these four types of ADR methods and for which cases they're most appropriate for.
Cool, thanks Ashley. So why should parties consider alternative dispute resolution in the employment tribunal?
So as set out in the presidential guidance, there's always a cost in litigation. So this can include financial cost, so legal fees, which in the employment tribunal are generally not recoverable even if you win. Reputational cost, this is going to ultimately be heard at a public hearing. There is the emotional cost, so obviously that's mainly aimed at claimants who have to go through the emotional turmoil and the stress of pursuing these cases, but it also can put a lot of pressure on managers who are dealing with the defence of the matter or witnesses who have to go through a tribunal process, which can be quite stressful for them. And also time. So it's time taken away from the business. It's time taken away from your life. It can take 12 to 18 months to resolve. So all of these things make litigation quite a costly process. And even with the cost aside, you've got the unpredictability of the employment tribunal. So any time when you're kind of reliant on witness evidence, cross-examination, you don't know how the evidence is going to go on the day. And so that results in a significant risk that you will lose. You don't know who the judge will be, where their leanings are, how they will use their discretion. So when you're going into an employment tribunal claim and leaving it up to a final hearing, you've got such a large amount of cost, a large amount of risk. When you go down the ADR route, this can give parties the ability to avoid having to incur all of that time and cost, and to find a middle ground or somewhere which will be beneficial or palatable for both parties. And you can negotiate terms that you wouldn't be able to within a tribunal wouldn't be able to award you a reference or a waiver of claims and training for staff things that you can, confidentiality terms, things like that, which aren't available as a remedy, but might be quite important. Sometimes claimants, may want an apology.
Yeah.
So, it gives you other options and allows you to mitigate the risk and cost of going through a lengthy tribunal case. The Employment Tribunal are required to encourage and facilitate ATR wherever possible and appropriate, and this will normally be discussed at a preliminary hearing.
Thanks, Ashley. So plenty of reasons to consider alternative dispute resolution then. And if you're dealing with an employment tribunal claim, whether as a claimant or a business defending a claim, and you would like to explore further what alternative dispute resolution options are available, then please get in contact with the employment team at Thompson Tanner Passmore.